All right, everybody, welcome to the Workers' Compensation Basics webinar, Part 3. I'm Janelle Matuszak. I'm one of the attorneys at Bugbee & Conkle. Today, we're going to talk about three things, kind of briefly since this is basics. We're going to talk about investigation of a workplace incident, wage loss compensation, and permanent total disability compensation. If you have questions, feel free to type them in and ask them, and I'll try to answer them as we go along. So we're going to start with investigation of a workplace incident. Just keep in mind, this pertains to a workers' compensation claim only. There might be additional things you need to know for a non-claim, but this is for an injury in your workplace. First thing, who's going to do the investigation? Generally, the best person is your supervisors. And the reason is the workers know the supervisor knows the workers. Supervisor a lot of times knows other things, sometimes things about the injured worker's personal life or their personal condition. They might know they already have a bad ankle or knee, something like that can help with the investigation. Also, they may have heard about rumors about the incident. They talk to other people in the plant. The other witnesses might be more likely to talk to a supervisor they know about what happened, rather than sending somebody down from corporate or somebody they don't know. And then, very importantly, the supervisors know the job and how it works, usually. And so they will be able to better understand what happened. It's kind of like when I go into a hearing, a lot of times what's written on the paper won't make a whole lot of sense, the incident report, because I don't understand the equipment, what it looks like, what it's supposed to do, where it was, and the supervisor knows all those things. So generally, your supervisor is going to be the best person to do an investigation. You want to fill out an accident report as soon as possible, and a lot of times I see the supervisor fill out one and then the injured worker fill out one. It's good to have two different forms. This is pretty basic, but you need to put the date and time that the injury happened. Make sure you have the time. It's real important. There's a big difference if it happened first thing in the morning or last thing of the shift. You want the exact location of the incident. If you're on a line and you have identical machines, specify which one it was and be very specific about what happened. Real important point is not to restate as fact what happened. I see a lot of incident reports where the claimant, if supervisor wrote it or somebody wrote it and says, claimant fell off a ladder. If you didn't actually see the claimant fall off a ladder or Joe fell off a ladder, you should write Joe said he fell off a ladder. Because when I get into a hearing and you have a supervisor sign or somebody from the company sign that says Joe fell off the ladder, the hearing officer will often take that as the supervisor saw that or knew that to be true. So just that little distinction can be really important. You want to get written statements from all the people involved in the incident and the witnesses. So Joe falls off a ladder. You want to get everybody around him to write something up about what they saw. And as soon as possible, because they'll start to talk to people, memories will change, their stories tend to change. The most reliable evidence is always the evidence that was taken closer in time to the incident. So the medical evidence, what the worker says to the emergency room is going to be more reliable than what they say to their chiropractor 2 months later after they've talked to their attorney and after they've had time to think about it. So get that evidence as soon as possible and look at inconsistencies. All right, so back to those witness statements and supervisor statements. Very important to make sure that the person writing out the statement signs and dates it. I get these all the time where I have a witness, it's handwritten, and there's no date, and I can't read the signature. So it's almost useless because I don't know who wrote it and when. So just those little things. If you can't read the signature, have them just write their name underneath it. Make sure there's a date, because like I said, it makes a big difference if they wrote this up the day before the hearing or if they wrote it 6 months ago right when it happened. Doesn't mean you shouldn't still allow people to submit witness statements right before a hearing. It's just that it's going to have a lot more worth if it's right after the incident. And make sure you get detailed description of the incident. Sometimes witness statements, sometimes they kind of meander around the incident and they never really talk about the incident. Make sure you find out what happened. look for signs of or evidence of drugs and alcohol. A lot of companies have policies where an injured employee has to go for a drug test following an injury. And if the drug test is positive, there is a way sometimes to try to argue that the claim should be disallowed based on that. And I could do a whole seminar just on that. But generally, either you have to prove that the alcohol use or the drug use caused the injury, and so therefore it's not compensable, just through medical evidence, or you can show that there was a reasonable suspicion that they were intoxicated or impaired, and that it caused the injury, and therefore the claim should be disallowed. It's kind of the same thing, but with a reasonable suspicion, the only difference is if you can get this reasonable suspicion that they were intoxicated or impaired, it shifts the burden. Then the claimant has to prove that their drug use or alcohol did not cause the injury, and the other way, the company has to prove it. The only thing you really need to know is it's easier if I've got a reasonable suspicion to get the claim disallowed. And so why I bring that up is when you're doing an accident investigation before they get to the hospital and have their drug test, if anybody is suspicious that they were impaired, they should document that before they go to the hospital or before they have their drug test. And they want to say why. So if it was because their eyes are bloodshot, they're acting goofy, or even because I know he uses marijuana before work every day, something like that. If there's any reason to believe, or maybe a coworker comes up to the supervisor and says, I think he was intoxicated, document that before they go to the emergency room. It's really important because once they have, if you have a post-injury drug screen as a matter of course, then the industrial commission is going to assume the only reason why they had the blood test or the urine test was because that's just the policy. They're going to assume there was no reasonable suspicion. So that's kind of a complicated area. Takeaway is just document if you think that there's any kind of substance use that caused the injury as soon as possible. I'm having trouble with my... Oops. Okay, another thing is obtain medical releases from the injured worker or the claimant for all treating physicians. Sometimes there's a smoking gun in the record. Sometimes we find evidence that they were having back pain 2 days before this supposed injury. You also want to get any records that have to do with any prior problems to the same body part. If it applies, photograph the incident site, all the involved equipment, especially if it's something kind of unusual that happened. Take measurements if you think you need it. You don't know what's going to be important later. It doesn't hurt to document it right away. If you don't end up using it, then you don't end up using it. It doesn't hurt anything. So things to consider during an investigation. Claimant's age is always important. I always look at, a young person is more likely to not be injured as severely through a simple incident. So if it's something really basic, they're picking up something that weighed 30 pounds and they say they hurt their back and they're 25 years old, that's something to wonder about why that would hurt somebody like that and to look into the medical a little more. Nature of the alleged medical conditions, are the alleged conditions way out of proportion to what happened? And unfortunately, you want to look at whether they're a good employer or not. You wouldn't think that would be relevant, but usually the bad employees kind of have a pattern. Sometimes they have a lot of claimed injuries, or there's often a disciplinary issue right around the injury, and that might cause you to be suspicious. Maybe somebody was just about to get terminated for absenteeism when they get injured. Those are just things to consider and document at the time that you're doing an investigation. Look and see if they have other claims. And as I said, disciplinary issues or attendance issues. That's really all I had for investigations. The important things are supervisor should be your investigator. Make sure when you document it, you say injured worker or employee said he fell or said he was picking up something. Don't state it as fact. They did hurt themselves. If there's suspected drug or alcohol use, document that right away. Get statements from witnesses, make sure they sign it, make sure that you can read their name. They might have to reprint it, and make sure they date it. So if you have any questions about investigations, go ahead and you can type those in and ask, and I'll try to answer them. So I'm going to move on to permanent total disability compensation. This is a little longer. Okay, so there's two types of permanent total disability compensation. If I say PTD, that just stands for permanent total disability. There's statutory and regular. Statutory is the one we don't see very often. It's payable when the claimant, as a result of the claim, has lost two or more body parts. And the way it's written here, there's sort of a story about that. So you have to lose both hands, both arms, both feet, both legs, both eyes. If this happens, so let's say a claimant loses both legs as a result of a bad workers' compensation injury, they're entitled to permanent total disability compensation benefits, and I'll talk about dollars in a later slide, but they're entitled to lifetime benefits, and they can actually go back to work and receive wages that way. There's no offset, so they can double dip. So it used to say statutory permanent total disability compensation was payable when they lost two or more body parts, but there was a bunch of litigation about if you lost your arm, did you lose your hand and your arm? Is that two body parts? And so for a while, that was considered two body parts until they changed the law, I think, in 2006. So that's why it's kind of written goofy because of lawyers like me, these loopholes. So regular permanent total is what you see most often. We don't see that statutory permanent total very much. But regular, and I should say the statutory permanent total can also be if you lost the use of both legs. So if somebody's paralyzed, that could be the basis to get statutory permanent total disability compensation. They still have their legs, but they can no longer use them. They could still get benefits that way. So regular permanent total is what we see most of the time. This is payable when the allowed conditions cause the claimant to be unable to engage in sustained remunerative employment, utilizing their employment skills that they have or may reasonably be expected to develop. Unfortunately, we don't see permanent total disability that often, but it's kind of the holy grail of compensation because it's lifetime benefits if a claimant gets it, so it can be very costly. It can be a big deal. It's not payable when one of the things on your screen happens. So the impairment is not the result of the allowed condition. That's pretty basic, but we do see that a lot. Injured people tend to have a lot of things going on. So you might get into a debate about whether they're not able to work because of the osteoarthritis in their knee, which is allowed, but then they have maybe a meniscus tear in the other knee, and they're both causing impairment. So the question is, which one is keeping them off of work? If the reason they're unable to work is solely to their age or aging, that is a defense to permanent total disability compensation. I'll talk about that a little more in another slide too. If the claimant retired or otherwise voluntarily left the workforce unrelated to their injury, that's also a defense to permanent total. And so if you have somebody who's any age, really 60, 65, and they've retired from their employment, they've got an old back claim. And then they're retired for 2 years, and then all of a sudden they need surgery, and the surgery doesn't go well, and they're more disabled. They file an application or a motion for permanent total disability compensation. Actually, I guess it is an application. But the company can say, he retired, he left the workforce not because of his back, because he was done working, his age, he had the amount of years in. He shouldn't be entitled to permanent total disability compensation because the theory behind permanent total, the reason it's there is to compensate a claimant for lost wages, and here the claimant was not getting any wages because they're retired. Also, under certain circumstances, the claimant has a responsibility to engage in educational or rehabilitation efforts. If you've heard of vocational rehabilitation, I think I may have covered that, I'm not sure, in one of the other seminars. But it's a process by which the claimant can use resources available to them from the Bureau. from the Bureau or the self-insured employer to help them find another job. So if they don't make any effort towards vocational rehabilitation, that can sometimes be a defense to permanent total. Okay, so I sort of touched on this. The inability to work must be used solely to the allowed conditions in the claim. So you can have other conditions that are disabling them. The claimant has to show that it's the allowances that are solely disabling them in order to be entitled to permanent total. So what I mean by this is, let's say your claimant has an allowed back claim allowed for herniated disc, several surgeries, so the back is in the claim. This claimant also has had a total knee replacement, completely unrelated to work. So obviously they have a bad knee causing some disability. If the claimant can show that the back standing alone would disable the claimant even without the knee, they wouldn't be able to work just due to the back, then they can be entitled to permanent total disability compensation. Occasionally, I'll have a claimant's doctor issue a report where they just kind of lump everything in, say his back and knee is preventing him from working. That's not good evidence. They need to show that they're independently disabled due to the allowed conditions. The fact that they have other things going on, like a knee that's not related to the workers' compensation claim, does not necessarily mean that you, as the company, has won your case, because the back alone could be causing them to be permanently and totally disabled. You should have medical evidence to address the issue. A permanent total disability claim, we're always going to recommend you get your own doctor, look at the claimant, and give an opinion as to whether the person can work, because we'll go over the procedures in a later slide, but the claimant's always going to file their own medical that says they can't work, so you're always going to want to get your own medical to fight that. And you do want to, when you're arguing the permanent total disability application, point out all non-industrial medical conditions for the company. What you need to do about that is be aware of it and bring it to your attorney's attention if there's other non-industrial conditions causing problems. Okay, so I touched on age, that I would talk about it again. Advanced age in and of itself is not a reason to award permanent total, and it's not always a complete bar. So you can have an 80-year-old claimant who files for permanent total disability compensation and win, as long as they can say, I would be still working if it weren't for this claim. And we'll see that sometimes with claimants, because they can file an application for permanent total, it can be denied, and they can just go right back and file another one in another year. There's no time limit. There's no limit to the amount of times they can file for permanent total. And so obviously they're going to get older and older, but there's never a point where we can argue that they're too old to get permanent total. They're always entitled to it, which is kind of a strange thing. Voluntary abandonment. This is usually retirement. If the claimant leaves the workforce for reasons unrelated to the allowed conditions in the claim, they shouldn't be entitled to permanent total. So usually person retired, and so therefore we argue it's not the allowed conditions causing them to be unable to work. The difference is if claimant can show they retired because of the allowed conditions, so the allowed conditions have to do with the back, because my back was so bad I could no longer do my job and I retired, then they could still be entitled to permanent total. But a voluntary abandonment could be other things. Maybe the claimant got fired and just never looked for another job. 2-3 years have passed. We can show they've shown no effort to look for more work, and so therefore they've abandoned the workforce. That sometimes can be a bar to permanent total. Okay, I mentioned this before, a lack of an effort for retraining or rehabilitation might be a defense to permanent total, and I'll explain a little more with this next slide. All right, so as I said earlier, the claimant has to show they're unable to perform sustained remunerative employment. When the claimant files an application for PTD, they're going to attach a medical report that says they're unable to do any work. Generally, the company then will get their own medical, and what the doctor will do is you'll ask them, can they perform any sustained remunerative employment? And if yes, do they have restrictions? So the doctor can say, no, they can't do any work, and then it's over, you lose. They can say, yes, he can do any work despite his back. And then they'll look at the scale, or no, that he can work, but he has these restrictions, and these are the different levels, the sedentary up to very heavy work. And so we often see the reports from our own doctors come back and say they can do medium work or they can do light duty work. So he can't go back to his old job, but there is some work he can do. And then at that point, that's when we take the position that they needed to do some rehabilitation in order to fit into these job categories. So let's say their former position of employment was heavy work in excess of 100 pounds. They could now only do light duty work. Well, we argue that the claimant had a duty to engage in some rehabilitative efforts to find a job within that light duty category, and therefore they're not entitled to permanent total. So vocational evidence, if you've got a report that says, the best thing is if you have a report that says they can do any work at all, no restrictions. But if you've got a report from your own doctor that says there's restricted duty, then you have to show that, so let's say they can do light work. You have to show that there is light work within their skills that they could do. And the way you do that is we usually recommend you get a vocational expert to write a report. That's what vocational evidence is. So it's usually necessary to defend a permanent total disability request. Not always. I mean, if your doctor says they can do any work, no restrictions, then it's not really necessary. You also usually have a bureau doctor. So usually between the three, the claimant's report, the bureau's report, our report, somebody's going to say restrictions are necessary. So we almost always need this vocational expert. It's just a file review, and it'll go through jobs in your area, what kind of things they can do. And the ability to perform work doesn't mean necessarily that they have to do full-time work. It just means they are able to do some work. Sustained work, though. So, the fact that the claimant could work for 8 hours on Monday, but then he can't work again for several weeks, maybe that's not sustained. So you have to show that they can do it over a period of time, even if it is part-time. So there's specific vocational factors in the rules that the hearing officer has to look at to decide whether there's work within their capabilities. So you've successfully shown that they can do light duty work. The hearing officer will look at these factors to see if there's light duty work they can do. So age is one of the factors, and so an older person doesn't necessarily, get permanent total because they're too old to work. But the hearing officer does look at whether they'd be able to adapt to new things. I don't know. It's kind of a minor factor, really, because they take the position that a person can work at any age. Education, though, is very important. An educated person is easier to adapt to different kinds of positions. An uneducated person will have a harder time finding a job. Work experience, obviously, things they've done before. If the claimant has computer experience, they're going to have better chances of finding a job or any kind of skilled work. They look at management skills. If the person was a manager before, the hearing officer might be persuaded that they can do that again. So the more work experience they have, the harder it is for them to get permanent total. If you have a claimant doing intensive labor work, they did that job for 30 years, they're now 65 years old, they have a 6th grade education, that person, I could see where the hearing officer would be more likely to find that they're permanently and totally disabled, because it's going to be very difficult for them to find a light duty job within their skills and education. So just going through the process, the permanent total disability process is very different than other things. Other kinds of compensation like wage loss and temporary total, permanent partial, generally those, the claimant files a motion, there's a hearing. And this is a little more complicated. The deadlines you have to look at a little more carefully. Here's the outline on the screen, but we'll go through each one. So first, the application is a bureau form where the claimant is requesting permanent total disability. They have to include a medical report which says they're permanently unable to work. due to the allowed conditions in the claim, and it has to be based on an examination within 24 months prior to filing. And I have at least one on this basis where the medical report was too old. So we have to look at that. If it's 26 months old, it should be an automatic win for the employer. Claimant has to make sure all the records upon which he intends to rely are filed at the time of the permanent total disability application. So they cannot get new medical records and file them the day before the hearing. This is the only time, I believe, that's true, maybe the SSRs. They have to file everything well in advance of the hearing, the claimant. So they can't really surprise you at the table on this one, or even the week before. When a permanent total disability application is filed, the commission will issue an acknowledgement letter, and there'll be some dates on there. Basically says permanent total disability compensation application was filed. Gives the employer 14 days to submit a letter to the commission that says that they intend to submit evidence. This is a hard deadline. You have to make sure that you do this. And then you have 60 days of the written notification to actually file the medical. So if you receive an application for permanent total disability compensation, you have to send the commission a letter that says, I intend to file my own medical evidence. That has to be filed within 14 days. And then you have 45 days after that, so a total of 60 days to actually submit the medical evidence. You have to get everything to the doctor, have an exam, have the doctor's report, and get it filed. There are circumstances where you can get an extension, but this is a pretty hard and fast rule. You don't want to wait 6 months and then try to file medical because they won't consider it. If the claim has both psychological and physical allowances, you might have to get 2 IMEs, one from the physical doctor, one from the psych doctor, and this happens kind of a lot because obviously the claims where the claimant is requesting permanent total are the more serious claims, so a lot of those have an additional allowance for depression or anxiety or post-traumatic stress disorder. In those cases, you need to get 2 reports. I recommend you get both, even if I've got one right now where it's allowed for physical and psychological. Claimant only filed a psych report, but I still recommend you get a physical report because the Bureau is going to get their own physical and psychological, and if the Bureau ends up with a report that says they actually can't work due to the physical, and that's the only report out there on physical, that's going to be really tough for you to defend that. If you're having trouble getting records under permanent total issue, really under any issue, if it's relevant to an issue pending, you can ask the hearing administrator to issue a subpoena to obtain evidence. This usually happens for whatever reason we have a provider that's not cooperating with our request for records. Sometimes we have to request a subpoena. And as long as you give them a reason, a good faith reason why you need it, usually you can get those. You can request a pre-hearing conference on permanent total. And they'll address issues like retirement, refusal of a written job offer. So with refusal of a written job offer, another thing you can do, if the claimant has restrictions and you have a job for them at your company, you can offer them a position within those restrictions. And if they can't do it, if they refuse to do that job that's within the restrictions, that can also be a bar to permanent total disability compensation. Other issues you might want to talk about at the pre-hearing conference are settlement, or maybe you've discovered that you need additional independent medical examination, something about when you get your exam back, you realize you need to have a neurologist do an exam or something like that. You can request those at a pre-hearing conference. I'm in trouble with my clicker. Okay. Good question. Somebody just asked, does the job offer have to be at the same rate of pay as the prior job? No, not at all. And so the next topic I'm going to talk about is wage loss. But under permanent total, if your claimant has restrictions, you offer them a job within those restrictions, even if it's part-time, even if it's lower paying, That's just proof that there's a job they can do. They can perform sustained remunerative employment. So if they refuse to do that job, they're not entitled to permanent total. Now, they can go and ask for wage loss compensation if they take the job. So if they're taking the job at a lower pay, they can request wage loss, which we'll cover in the next couple slides here at the end of the slide. So that's a really good question. So it does not have to be the same rate of pay. And that's a different thing about permanent total, too. So when you're trying to get temporary total denied, the standard is whether they can return to their former position of employment. For permanent total, the standard is whether they can do any job at all, sustained. Some people can work a little bit here and there. You might see them working at a garage sale for 4 hours 1 month, but it has to be a sustained schedule. It doesn't have to be full-time, it just has to be sustained. Okay, so an SHO can deny permanent total, obviously, if they don't meet the definition of permanent total. Slide to work better. If the person's actually working, that happens occasionally where they're requesting permanent total and you can find out that they're actually working. Obviously, that's a bar to permanent total. If they're medically able to return to their former position, that's a bar. If they voluntarily remove themselves, that's the retirement I talked about. If they're offered a job and they refuse to take it. Another one is if the allowed conditions have not reached maximum medical improvement. That's a treatment plateau where they're not going to get any better. So if their condition isn't stable, they're not at maximum medical improvement, they're not entitled to permanent total yet, at least. For example, somebody has a surgery right before their examination on permanent total. Your doctor might say they're not recovered enough from the surgery to be at maximum medical improvement, and so therefore I can't give an opinion or whatever. That could be a bar to permanent total. That doesn't happen very often. Usually permanent total comes up way after they're at maximum medical improvement, because if a claimant is not at maximum medical improvement, they usually try to get temporary total. Or if evidence shows that their age is the sole cause of their inability to work, that can be a bar as well. So in the hearing, I think I might have skipped over this. So what actually happens, so when you get your own exams, the employer gets their own independent medical examinations, and let's assume that they're good reports and say the claimant can work in some capacity, then the Bureau will actually get their own medical as well, a little bit like a permanent partial. So they'll have a doctor examine them on the physical and psychological, if they're psychological in the claim, and issue their own reports after that, and then they'll finally schedule it for hearing. It takes at least 6 months from the time the application is filed to get through the whole process, because there's several exams. So once you get to hearing, if the hearing officer says this person can't do any work at all, that's the end of the story. They don't need to look any further than that. There's not even any restricted work they can do. You can grant it there. I skipped one. No. Okay. So things that the hearing officer will look at is whether the inability to work is solely due to the allowed conditions. The burden is solely on the claimant to prove they can't work. And the commission has the authority to determine all disputed facts and to waive the evidence. If you lose permanent total, you can file a mandamus action in court. And you could ask for a reconsideration, but generally you just get one shot on a permanent total. It's the hearing officer. They get to decide it, and if you don't like it, you don't get another level like a lot of other issues. You can take it to court, though, if you'd like. Another fun thing is, if a claimant is awarded permanent total disability compensation, they can request a lump sum advancement in order to pay their attorney. So the attorney can get up to $15,000, so we always see this, where once it's granted, the attorney will file a motion requesting a lump sum advancement of $15,000 so they can get paid. And that's permissible as long as it doesn't reduce the claimant's payment by 20%. So they'll advance $15,000 and they'll reduce subsequent payments by a little bit every week in order to recoup that $15,000. So how much is permanent total worth to the claimant? It goes by the claimant's average weekly wage rate, so their average weekly wage for the 52 weeks prior to the injury, come up with a a number, and then they get 2/3 of that number. Same thing as temporary total. So for a 2019 claim, the maximum rate is $950 a week, which is almost $50,000. And benefits are payable for life. So you can see how this could be very costly, especially if your claimant is a fairly young person. I think that's everything on permanent total. And if you're state funded, even though the claim only hangs out on your experience for 4 or 5 years, it can be costly enough, especially with that lump sum advancement and some other things, that it can really affect your rate. So something that you want to make sure you're paying attention to the deadlines on permanent total. It's different than a lot of other things, and fighting those, because they can be a really big deal. So I kind of alluded to the fact that I was going to talk about wage loss compensation. Wage loss compensation is another area of compensation. And the theory behind wage loss is if the claimant is no longer able to earn as much as they used to earn due to allowed conditions in the claim, they're entitled to be compensated for that. So it's not permanent total because they are able to do some work. They're just not able to do the work they did before. And it's not temporary total because temporary total is payable up until the claimant has stabilized, has reached maximum medical improvement. So usually we'll see wage loss after temporary total is terminated. There's been a hearing, claimant has found they've reached maximum medical improvement and no longer entitled to temporary total. And the claimant says, I still can't go back to my job though, what am I going to do? At that point they can request wage loss. 2 types of wage loss: working wage loss and non-working wage loss. Under the wage loss rules, a claimant can request wage loss even if they're not working. There's a process by which they will file an application for wage loss, and they have to show they're looking for a job within the restrictions, but they can't find one. And if they can meet all the requirements, which we'll go over in more detail, they can get non-working wage loss compensation, which is basically getting more temporary total. It's an extension of that because they haven't been able to find a job. Working wage loss happens when they have found a job, and due to the restrictions, it's lower paying. Sometimes it's part-time. Sometimes it's just more menial job, like they're Walmart greeters, so they're not making as much money. Then they're entitled to some compensation to try to make up for what they're losing from their prior job. So temporary total can go on forever until the claimant has reached maximum medical improvement or returned to work. There's some other situations, but generally those are the 2 things. If their doctor says they can return to work, even if they haven't returned to work, it's cut off. But there's no end point specific to temporary total. I had one where a guy was off for 9 years on temporary total for his carpal tunnel, cubital tunnel. He kept having surgeries. That can happen. Wage loss is a finite time period. So you can get up to 200 weeks of wage loss compensation. For some reason, they wrote into the code that the first 26 weeks of non-working wage loss don't count against the 200. So what that means is if you can get 226 weeks, if at least 26 of them are non-working wage loss. I don't know why that is. But so that's over 4 years. It can be 4.5 of wage loss. So it's significant, but there is an endpoint. Living maintenance wage loss is when claimants in a vocational rehabilitation program. We touched on that with the permanent total. If the claimant has restrictions and wants to get permanent total, they should try to get into a vocational rehabilitation program to try to look for another job. While you're in vocational rehabilitation, though, you receive living maintenance, which is just like temporary total, but they call it living maintenance, and it's technically a wage loss payment, and that does count towards your 200 weeks. Unfortunately, we see a lot of claimants who want to get permanent total. They'll go through the steps like they're supposed to for vocational rehabilitation, but they're just kind of phoning it in so they can say they did it. And then when it comes to permanent total, that won't be a bar to their compensation. Okay. And I think living maintenance is I'm pretty sure it's 26 weeks unless they can ask the commission for more. Generally, they don't need that much. I don't know if I've ever seen one where they've asked for more living maintenance. Okay, this is new wage loss rule, but now it's been a few years. But they did completely revamp the wage loss rules in February of 2014. What you need to know about that is sometimes they will change a rule, but it'll only apply to new claims. This rule applies to all claims, all applications for wage loss filed after February 13 of 14, which makes it easier, so because we don't have to look at two different rules for different claims. Within the rules, they define present earnings, and present earnings just means the injured worker's actual weekly earnings. They could be from commission sales, bonuses, gratuities. These are what they're earning now at their new job, which pays less. Which is why they're claiming they need a wage loss, a job within the restrictions. There's a rebuttable presumption that earnings from paid leave are included in present earnings. And there's a rebuttable presumption that claimants who are self-employed have a gross income or present earnings of at least half of the statewide average weekly wage. So what is this, the rebuttable presumption lawyer term again? That just means it's the claimant's burden. The commission assumes that any money from paid leave is part of their earnings, and they assume that if they're self-employed, they make at least half of the statewide average weekly wage, which is $950. So they're going to assume they make at least $475 a week through self-employment, unless the claimant can prove otherwise. It's the claimant's burden. It's just a shifting of burdens. You could see how if claimant was self-employed, how it's easier to manipulate their income. So your claimant can't return to work with you at your employer, so they've gone into business for themselves, something light duty. Let's say they're mowing lawns or something, if that's light duty. But they can take what they make at that job, even though it's self-employed, and claim a wage loss and get some compensation. But the commission will look at that with more scrutiny because it's easier to manipulate what you're making at self-employment. Excuse me. Okay, so the application. There's a specific wage loss application you have to fill out when you request wage loss compensation. You have to attach a medical report, and the medical report has to contain the claimant's restrictions due to the allowed conditions in the claim, an opinion as to whether those restrictions are permanent or temporary, an opinion about if they're temporary, how long they will last, and has to state the date of the last medical exam. The medical report has to be based on an examination within the last 90 days. So permanent total is 2 years ago. The exam can be 2 years old. Wage loss is 90 days. As of 2014, now they require the claimant to list their entire job history, every job they've ever had on this wage loss application. And if they're looking for work, they need to fill out these wage loss forms. It just says where they looked, who they talked to, when it was, what the response was. You know, there's questions like, were they given an interview? So again, if it's non-working wage loss, they're looking for a job within the restriction, they can't find it. They fill out these wage loss forms to prove that they're working, and they can receive wage loss compensation. If they are working, they have a duty to keep searching for comparably paying work, which I will explain in another slide. So I talked about there's different rules for permanent restrictions and temporary restrictions. Before 2014, the claimant had to get a statement from their doctor about what their restrictions were every 90 days. The doctor had to say whether it was temporary or permanent, but they still had to do it every 90 days. Now, if the restrictions are permanent, the commission says you don't have to supply new restrictions unless the employer asks for it. And the employer can ask for it every 180 days, which you should do. Because that's an easy way to get wage loss denied if the claimant fails to give you the restrictions, which actually happens kind of a lot. Temporary restrictions have to be certified every 90 days. That means they have to go back to the doctor every 90 days to get restrictions. Under the rule, claimant also has to register with the Ohio Department of Job and Family Services and file proof of that. Technically, working wage loss can be payable if claimant has to leave their job with you for treatment, as long as the treatment is necessary for them to continue working full-time. Claimants don't a lot of times ask for this because, let's say they have to take a Tuesday off because of a medical appointment. They're only entitled to 200 weeks of wage loss. So a lot of times their attorneys will deem this to be a cheap week if they've only missed 8 hours of work or 6 hours of work. They don't want to use one of the weeks on something like this. So we don't see that often, but it is possible. There's an offset for short-term disability. This is the same for temporary total. If the employer has fully funds short-term disability, if they're receiving short-term disability and temporary total, there's an offset there, and wage loss compensation, there's also an offset. So if a claimant qualifies for temporary total, they're unable to return to their former position of employment. If you offer them a light duty job, they come back to work light duty, that can be wage loss if the job is, well, it could be temporary or permanent. That can be, your light duty job can be a wage loss situation. If they ask for wage loss, they can ask for temporary total, they can ask for wage loss. If restrictions are permanent, that would be wage loss. But they do not need to search for any other work. If a company where their claim originates offers them a light duty job, they're automatically entitled to wage loss compensation, which was not always the case. Under the old rule, they were supposed to keep looking for work in order to try to eliminate that wage loss. So their former job, they made $25 an hour with you. They can't do that anymore, but you have a job where they make $20 an hour. They used to have a duty to try to find another job that pulled them back to the 25, but that's no longer the case if they go back to the job where they're injured. So they have a duty to look for suitable work, and suitable work is work within the restrictions and any other limitations they had before the injury. If a claimant is seeking wage loss compensation, especially if it's non-working wage loss, they need to first ask their employer, their former employer, if they can have a job with them. The exception is if it's futile. If they were fired or that place went out of business, then they won't have to ask for a job with them. But otherwise, they need to first ask for a job with the employer of record. Then they need to do a good faith job search to look for suitable work that's comparably paying to their old job before receiving wage loss. Even if they've returned to full-time employment, let's say they took a job making minimum wage and their former job was $25 an hour, they might still be entitled to wage loss, but they have to continue to look for a higher paying job to help mitigate the wage loss. And these are pretty winnable because a lot of times claimants will show maybe one job search a day, and they're supposed to spend a pretty good chunk of time looking for work, especially if they're working part-time. So if they're working 4 hours a day, they should really be spending the other 4 hours looking for comparably paying work. So you want to really look at those applications and the job search before just granting wage loss. A lower paying job must be necessitated by the work-related disability and not by a lifestyle choice. So, claimant can't take a job because it's close to home or because they like that job better. They really have a duty to look for comparably paying work. And so any loss in wages has to be related to the allowed conditions and not to some kind of lifestyle choice. They have to make a consistent, sincere, and best attempt to obtain suitable employment to eliminate the wage loss. And the good faith job search means they have to really be trying to get a job. They can't send out applications and then take their phone off the hook. They have to really try to look for work. And unfortunately, it's sort of hard to prove that they're making a good faith effort. We have before sent out investigators to make sure they actually applied and they're just not making up the job search. But there's not a whole lot you can do to prove that they're tanking the job, because you can see a situation where a claimant could apply, but then, give a poor interview or something like that and not get the job on purpose. So we're going to go through a couple examples here. A claimant returned to work part-time and a job search was excused. There is a narrow exception. Claimant returns to work part-time for another employer. They have a duty to try to eliminate the wage loss. So they're supposed to keep looking for work that with comparably pays to the prior job. Here, the job search is excused because there's a strong potential the job would become full-time. There's a couple cases on this where the claimant took a part-time job because they heard a full-time job would eventually become available and they choose from the part-time people, or they're promised if they worked part-time for 2 months, then it would be full-time. Those kind of things, the commission will often find that they did not need to keep searching for a higher paying job because there was potential it would be full-time. And the language they kind of use is they should not be required to leave a good thing to mitigate the wage loss. So this is an actual case. Claimant returned to work for his wife's business at a significant reduction in pay after only looking for work for 5 weeks. He made 37 contacts, which seems like a lot, but over 5 weeks, that's 7 job searches a week. It's 2 a day, 1 or 2, which, I mean, maybe an hour. So the court looked at this is not a sufficient job search. You didn't spend that much time on it before completely giving up and working for your wife at a significant pay discrepancy. And as I said before, they really give it close scrutiny if it's self-employment. I think it's the same thing if it's working for your wife. Okay, so lack of overtime can sometimes create a wage loss. Oftentimes, a claimant's restrictions are hourly restrictions. They can only work 30 hours now, or they can go back to their job, but they can't work overtime anymore, which sometimes can be significant. So there are scenarios where where the claimant requests wage loss compensation. They went back to their old job, but they can't work overtime anymore, so they've lost money. They're entitled to wage loss for overtime if the restrictions are due to the allowed conditions, and those restrictions cause the claimant to be unable to work overtime. For some reason, this case doesn't make a lot of sense to me, but there's no working wage loss if claimants move to a department that doesn't offer overtime, even if they're moved because of the allowed conditions. There's just Chrysler case. But generally, there's 2 key questions. Was overtime offered and refused because of restrictions? So did everybody else in the department get overtime, but this person didn't because of their allowed conditions? Then they're entitled to wage loss for the pay discrepancy. Or we look at why wasn't it offered. If it's an economic reason, nobody's getting overtime anymore, even though they're making less money this year than they did the year before the injury, they're not entitled to wage loss because it doesn't really have anything to do with the claim. If they're singled out because of the injury, everybody else got overtime, then wage loss is payable. So if it's a business reason, they're not entitled to wage loss. And what they look at, they don't look at what you would have gotten had you worked wage loss or had you worked overtime with everybody else in the department. They look at your average weekly wage, which is based on the year before your injury. And so if your average weekly wage is $950 a week, but this week he made $750, the next week he made $850, and he missed out, and the reason for the discrepancy is because overtime was offered to other people in the department, then it's based on that original average weekly wage of $950, not on the actual overtime that would have been given. It's a little confusing. So here's an example, kind of an easy one, the way wage loss is payable. Here, average weekly wage, I picked low numbers just to make this easy, is only $300. PE is present earnings, so what they're earning at their new job. Let's say they only make $100 a week. So the working wage loss is 66 2/3% of the difference between the average weekly wage and the present earning. So here would be $133.33. It cannot exceed the statewide average weekly wage of $950. The reason why it's not the full difference is because it's not taxable. So we try to make up for it that way. And temporary total is the same way. Permanent total is the same way at 66 2/3%. There are 2, I think everybody knows because you probably got sent a link, but just in case you missed it, I did 2 other workers' comp basics webinars over the last year, available on YouTube, and there are also links, I think, on our website. And in those, I talked a little bit more about temporary total. I talked about the basic terms for workers' compensation because it does have its own language. We went over AWW a little more, and I also discussed why some things are compensable workers' compensation claims and other things are not. So those are also good resources to review, and give us a call if you have any questions. Thank you.